Today, I'm going to be talking to you about some of the legal tools that are used in discovery during the litigation of your case. Litigation means that now a lawsuit has been filed. A deposition is a formal, out-of-court, sworn oral testimony that's taken before a trial. And it's used to gather information, assess witness credibility, and it involves questioning to a witness, to a plaintiff, or a defendant in the case. And during a deposition, all of the testimony is transcribed. So there is a court reporter there who is taking down or typing all of the information that's said during the deposition, and that information is then put into a transcript that can be used at a later time, typically at trial. And so a deposition is a very important part of the discovery process, and it's one that pretty much happens in every single case, no matter if your case is in arbitration or going to trial. When it comes time for the deposition in your case, at Kaplan Law Group, we make sure that our clients are very well prepared so that you're able to give your best testimony that day. Typically, the deposition is either held in a conference room at one of the attorney's office, either at our office or opposing counsel's office, or a lot of times they're still being held via Zoom. So whether it's in our office or somewhere else or via Zoom, we always want to make sure that you know what to expect. So basically what happens is you show up for the deposition, you will have your counsel present, and then the counsel for the defendant in the case will be there as well, along with the court reporter. The court reporter, before the deposition starts, will swear you in because your testimony is under oath. So even though you're not in a courtroom, the same rules apply as far as telling the truth. After the ground rules, typically the defense counsel will move into some background information about you. So general questions about who you are, where you came from, questions about your family or your job, and then they'll get into the facts of your specific case. So during the process, you might hear objections made from your attorney. And those objections are to preserve the record for a later time. So a lot of clients think, why are they asking me this question? This doesn't have anything to do with my case. But there's a broad range of questions that they can ask you. Basically anything that could possibly lead to the discovery of admissible evidence. And so our job is to make sure that if we believe there's a question that's asked incorrectly or that's maybe not relevant, we state the objection before your answer so that we can argue about it later on. There's rarely a time that your counsel will tell you specifically not to answer that question. In those cases, it's typically because they've asked you some sort of communication that's attorney-client privileged. But for the most part, even if we make an objection, you can still answer. And I do have clients that feel uneasy about that, but I just remind them before the deposition that just because you're asked a question and you answer doesn't necessarily mean that that answer is coming in at a later time or at trial. So again, at Kaplan Law Group, before your deposition, we typically spend about an hour with you, just going over the accident, refreshing your memory, talking to you about your injuries and your treatment and how the accident affected your life so that you're well prepared. So if your case is in litigation, don't fear. At Kaplan Law Group, we will make sure that you're very well prepared for any sort of discovery process like a deposition. If you have any questions about your case, no matter where you are in the process, please give us a call at 702-381-8888.